what the law that supports you is. So it should have been a matter of relative ease. In fact, even easier for you, Ms. Vandenheefer, Mr. Matlala's lawyers, to argue the law than it would be for the evidence leaders on whom you are springing these points in limine. So I'm not sure that I follow your response. Can you tell me why written submissions were not or could not be filed on legal issues that were the start of all this, legal issues that you thought of even before commencing this the process that we have before us this morning? And underlined, you were ready with the law right from the beginning. Otherwise, you would not have even considered bringing an application in which points in limine were being raised.
Chair, I can only take you back to the fact that from our consideration was that it was imperative for us to prepare the replying affidavit. My apologies. From our considerations, we found it or deemed it imperative for us to prepare the replying affidavit and to get further instructions from Mr. Matlala with regards to the position that we're taking. And I do note the point that you're making that perhaps what we could have done in the interim was prepare the heads of arguments to assist the commission and have them filed on time. I take note of that, Chair. But that was a delay that came as a result of the consultation, the considerations that we had to make, which is that given the answering affidavit, we deem it important to get further instructions from client with regards to the replying affidavit before we proceed with penning down the position that we've taken with regards to the application. That's as far as I can take it, Chair.
Morning, Ms. Missy. The point is simply this. Mr. Matlala would not have assisted with the law because the law is for lawyers to research and to argue. He could only have assisted with the facts and the giving of instructions as far as whether he wants to persist his application. But the law is for the lawyers, and the moment they advised him to bring this application, this was the time to start considering, especially being aware of the strict timelines under which this commission operates. We simply cannot afford a wasted day because our schedule is already very tight, and that is the difficulty we find ourselves in.
Commissioner, it goes back to the considerations that we made. If I have to make further submissions, then I have to make up stories, and I'm not prepared to do so. What I have explained to the Commission is the step-by-step process that we've gone through, and I do take note of the points that both yourself and Chairperson are raising. Thank you.
Yes, Ms. Hassim. Perhaps let me just ask this quick question of Ms. Silo. How much longer do you think Mr. Matlala's testimony will take? I know those estimates have regularly been overshot.
I know, Chair, and in this case, it shall be particularly so because Mr. Matlala's testimony in truth hasn't even begun. So all he's done is read his statement into the record, which he has sort of supplemented through this application. I guess he may want to place that also on record. We had anticipated a minimum of 2 days after he has placed his statements on record, Chair.
So today and tomorrow?
Today and tomorrow. A minimum of 2 days. Thank you, Chair.
All right, thank you, Mr. Yes, Ms. Hassim.
Chair, just a few responses to what Ms. Misi has submitted. The first is, and just to correct some of the facts. The first point relates to the filing of the founding affidavit. It was due at 10 a.m. on Friday. This was subsequent to the directive of the chair that was made on Monday. So there was a long period between Monday and Friday for the purposes of consultation with their client before the filing of the first affidavit. So the long explanation that was given about the difficulties with accessing the client in correctional services doesn't really assist in relation to the founding affidavit because there was sufficient time. But it's not only sufficient time from the period between Monday and Friday last week. Mr. Matlala's legal representatives have been raising this issue for some time, prior even to Monday. They are aware of the categories of evidence that the evidence leaders wish to canvass with him in questioning. They've known this since at least March of this year. So this application could have been brought much sooner. And so all of the time, in fact, that was available to Mr. Matlala's legal team extends over months, not over days. So that's just to address the founding affidavit and the explanation for the lateness, which I say doesn't assist Mr. Matlala's team. The second point is about the heads. And I'm not going to repeat it because, Chair, you've made the point and Commissioner Khumalo has made the point. Those are legal, that's legal argument. There's a legal team that's assisting Mr. Matlala. The heads of argument could have been submitted timeously and they weren't. There was no need for consultation in relation to the heads of argument. Preliminary points are by their nature legal submissions. The second...
Please continue.
On the point of the legal submissions, you would have seen from our answering affidavit that we set out the legal principles. It's not true that this is not circumstances that have arisen in the commission before. That is not correct. The authority that we have submitted to the commission that we say is the controlling authority is the Secretary of the Judicial Commission versus Zuma, the Constitutional Court judgment, and specifically the judgment by Justice Jafta, which was a unanimous judgment. And we referred to paragraphs of that judgment, which we say is the governing authority to be considered here. So the law on how one should deal with the assertion of the privilege against self-incrimination in a commission.
Just explain the point about the judgment having been unanimous.
The judgment by Justice Jafta on the point of self-incrimination and the assertion of the privilege against self-incrimination in a commission of inquiry. So that's a judgment on which we have relied. We set out the legal principles in the answering affidavit even before we filed our heads. That's just in relation to the point on the privilege, the section 3, subsection 4 point. The second legal point was in relation to unconstitutionally obtained evidence. And there too, we set out the legal principles in the answering affidavit even before we got to the heads of argument. And the point I'm making is that these are legal submissions. That's why our affidavit sets out the legal principles. And there we explained why the argument that Mr. Matlala is entitled to blanket immunity from questioning in relation to broad categories of topics is not available. It's not a competent relief that they were seeking from this commission. That was already set out in our answering affidavit. So it's not correct that there's no law on this and that they needed to have more time. Quite apart from the important points that you and Commissioner Khumalo have already made, that this is something that's been brewing for some time by Ms. van den Heerfer. The third point is just in relation to, I just want to correct the Dlamini affidavit. It is correct, it's true that the Dlamini affidavit was filed with the commission and submitted to Mr. Matlala's legal team this weekend, but that's not part of the application that's before the commission today. It's entirely separate, and that should not hold up the argument on the application. Those actually are my submissions, Chair. I think that the commission will decide on how much of time, if at all, any time is to be granted to my learned friends. But the argument is there from our side. We are ready to respond. Our concern as evidence leaders, as we've contained, as we've set it out in the heads of argument, we wish to have the application dismissed, and we want the questioning of Mr. Matlala to proceed immediately because time is short.
Our replying affidavit and our heads of argument. And so what the instructions are is that our application on an urgent basis would interdict the proceedings of the hearing or him giving testimony pending the reviewing of the ruling that you would have made, which is that we must proceed with arguing this matter, because he's of the view that it's unfair that he's been placed in this position where he has to proceed without Van der Heerwe, who is his lead counsel, and without heads of arguments before you, which he believes then implies that we are not properly prepared and we're being strong-armed into proceeding.
Now, this time around, you've not said anything about the afternoon. It's what you said about the afternoon that I want to understand.
Yes, Chair, what I meant is that if we stand out now, it'll imply that we only have this afternoon and evening, I suppose, to ensure that we get the documents before the commission. So that's what the afternoon referred to, that if you do change a ruling into us standing down or postponing until tomorrow, it means that it's just this afternoon that would have to ensure that we have bring the documents or serve them on the commission and the evidence leaders. That's what the afternoon was.
No, you keep repeating that because you don't have your written submissions, you are not ready. Written submissions, yes, they do assist legal representatives, but in the main, written submissions are prepared for the assistance of the decision maker and not so much the arguer. Do you want to address us on that distinction? So those would more have been of use to us, but seeing that the written submissions are not there, we are prepared to forego the assistance we would have received from your written submissions. So as I say, it's more for us than for you.
Chairperson, having engaged with client afterwards stood down, and obviously with what he had heard during our discussion, his instructions to us is that his observations and his views is that if Ms. Van der Heerwe is not here and we have not prepared our arguments for you, it implies that he's not going to be properly represented and he's not comfortable proceeding, which is why he's intimated that should the ruling not be changed to allow us to stand down until tomorrow, it implies that he's of the view rather that he's being treated unfairly and he would rather approach a court to have that addressed, Chair. And I do note that you're distinguishing the difference between written submissions and who exactly they're meant to assist, but it's client's instructions that he's of the view if his lead counsel is not here, together with us having not produced the heads before this commission, that he's not properly represented. And unfortunately, I can't comment any further than that because, as you do know, myself and my junior, my apologies, Chair, I forgot to put Ms. Brighton onto record. She's the third junior on the matter. And consequently, he's of the view that he's not willing to proceed, and he would like an opportunity to have this addressed before a court, Chair.
May I ask an issue that we did not raise before? It is this. Why is it that there is no substantive application for a postponement with sufficient clarity? Now it has just been emphasized to us that, as I understand it, the main reason is the fact that lead counsel is not here. Why is it that no substantive application for a postponement on affidavit was brought?
Chair, I think for one, we did not anticipate that we would find ourselves in a position where we were not able to firstly consult with Mr. Matlala yesterday to get the additional information that we needed. Before we left, I did intimate that there is a document that is important, and it speaks to one of the bases upon which we bring this application, but it's obviously of a factual nature. He had to bring it here in the morning, so that's one element. The fact that we didn't anticipate not being able to prepare the replying affidavit. Number two, that then created circumstances that follow when we were not able to proceed and prepare the heads of argument on time to be before, to serve on the evidence leaders and for the commission to have signed off. And so those are the reasons why we were not able to prepare ourselves on time to, or rather, finally, we hadn't anticipated that Ms. Annalene would fall so ill to a point where she's unable to even be here in person. Because perhaps her being here in person as the lead counsel, we would have had a better argument, so as to say, and maybe have created way for us to proceed to argue on a legal basis. But one thing I can say is that our instructions from client is that if his lead counsel is not here, he's not comfortable and he doesn't feel properly represented.
But the main reason throughout for not proceeding today is the fact that you did not have all the documents you think you require, and that was known for quite a while back, and that had nothing to do with Ms. van den Heever's being here or not being here. So at some point, especially because this morning a postponement is sought on the basis that these documents are not available. Your argument, that was the gravamen of your argument this morning. A reference to Ms. van den Heever not being well was something that was said in passing in your argument. Main reason, the fact that no replying affidavit had been filed, and also the fact that written submissions had not been filed. So the short point I'm making is that that's something that was known for quite a while. At some point, a decision should have been made that, seeing that we don't have these documents, and because we do not have them, we are going to seek a postponement. Let us bring a substantive application for a postponement. That's the point I'm making. The issue about lead counsel not being here arises because I have now directed that I want to hear, that we as a commission want to hear argument on the application, on the points in limine. That's when now the issue of Ms. van den Heever's absence takes center stage, and that has nothing to do with why this morning you argued that there should be a postponement. I hope you do get that distinction. Can you address me on that distinction in particular with regard
Chair,
to...
I do
just
get it.
let me finish.
Okay.
With regard to why there is no substantive application.
Chair, firstly, I'm just getting notes from a junior. Ms. van den Heever would have been prepared to argue the matter whether there were papers before us or not. That's the first point. Secondly, we don't anticipate an instance where she would be ill and not be in a position to appear before the commission, which is why we were unable to prepare a written postponement. Because in the morning when we engaged with her and she was being rushed to the hospital to go and have her ailment addressed, we hadn't anticipated that she would not be here in person in time for us to then prepare a written postponement application. What I can assure is that the letter that you sent indicating that you haven't received a postponement application and will proceed absent of that application, we received it at around 7:30 in the parking lot of the venue where this commission is being heard. And so, Chair, could we have prepared the postponement application? If we were in this position that we found ourselves in the morning the night before, we would have endeavored to prepare the postponement application. That's with certainty. But because this is something that happened to us in the morning and my instructions were to come before the commission and to ask us to postpone only till tomorrow, that's the reason why you don't have a written postponement application.
Now, I just want to get an idea of how things are to unfold in the event that I'm not saying we are adopting that stance, but in the event that we adopt the stance that we go ahead with the hearing of Mr. Matlala's application, how will things unfold then? Will you walk out? Will you withdraw as Mr. Matlala's legal representatives? I just want to get an idea of how things will unfold. Going further and saying, if we get to a point, and underline if we get to a point where, having heard Mr. Matlala's application, we do not grant it, and we go ahead with the hearing of his evidence in the normal course, with him, of course, being entitled to raise whatever privilege he may want to raise. So I want you to address me with regard to how things unfold, even looking ahead up to and including that furthest or farthest point.
So, Chair, as you rightly pointed out, it's either one of two options, which is the fact that it would be removed off the brief as his counsel and possibly even his attorneys. The alternative being that you would grant us another ruling, which is perhaps to say within a certain period of time, please ensure that you've served and filed this urgent application with your Part A and your Part B to review my ruling, and at which point would get the opportunity to do so. I must say I wouldn't have...
The application, the interdict, I assume that's a High Court interdict, so time frame with regard to that would have nothing to do with us. So...
of us ensuring that we've served you here and not what the High Court or the senior judge sitting would determine would be the ideal time for the urgent to be heard. That's just, again, ideas that I'm throwing out.
And may I, sorry to interrupt you. And as you are making your submissions, again, bear in mind, I started with two big ifs. If we reach that point, you should be aware that there will be no interdict in existence at that point, which would mean that nothing stops the Commission from going ahead and hearing Mr. Matlala's testimony.
Chair, as I said, that we hadn't foreseen an instance that the Commission would possibly consider not granting us an opportunity to approach the High Court and address the application that we seek to be heard on an urgent basis. And if that is the case, I don't want to preempt what we would do if you decide not to grant us that opportunity, because for me, it's a matter of you're either changing your ruling, allowing us to stand down till tomorrow. The alternative, you say, no, I'm not granting it, at which point the question as to whether are you going to rule to say, okay, since you've intimated that you want to have my ruling heard on an urgent basis and reviewed, then you are welcome to do so. I excuse you. But if you choose to proceed without excusing us and thereby Mr. Matlala, I would then ask for a stand down, because then there are implications on him that would affect us, i.e., for one, walking out, and who gets to walk out, and if, for instance, counsel is removed off the brief, what are his options, and should he decide that he wants to walk out with us because he feels that he's being unfairly treated and is not being given an opportunity to be heard till tomorrow morning, with our undertaking being that whether Ms. van der Heever is here or not, we would have to ensure that I, being then the lead counsel, is prepared to continue and present before the Commission. Then again, as I stated, we hadn't taken instructions with them. I think it would give us if you could give us an opportunity to stand on further, depending on what your ruling is, to engage with him and consider what the implications would be, because there are different implications should you decide to protest and want to walk away, and who gets to do the walking away and what those implications as well would be, Chair. I think it's wrong for me to preempt the instance where we decide, because walking away seems to imply that we are protesting, because we'd be walking away in protest. And if you walk away in protest, we've seen in previous instances what the implications are, and the client would have to consider that, and he'd have to give us instructions, Chair. I can't preempt to answer your question.
Thank you, Ms. Missy. Ms. Hassim?
Chair, I've been listening closely to my learned friend, and it feels like the reasons keep shifting for how we've come about to be in this position. Whether it's because the last submission that Ms. Messi made was that she would make an undertaking to proceed to deliver the argument in the absence of her leader. But if that is the case, then what would be the need then for the postponement? So, and for the urgent interdict? It's not entirely clear to me. It seems to me that, and I have some sympathy for Ms. Messi and Ms. Brighton. The juniors are placed in a difficult position where they have to step into the shoes of their leader. The leader has become unavailable for reasons not in her control. This is what happens in practice. And we are often called upon to step into the shoes of our leader on short notice and to be prepared to do so. It's not an easy position, but it is one you assume when you take on a brief and your junior counsel. While I have sympathy for their position, it doesn't absolve them of their obligation to take the place of the leader. They were aware that Ms. van der Heever would not be available today. This could have been brought to our attention much sooner. One of the reasons that was advanced by Ms. Messi for the delay was the inability to consult with the client. That is not a ground, an adequate justification for a delay. That was in response to the chair's question about why didn't you bring a postponement application? Because it isn't the inability to consult on the law doesn't avail Ms. Messi on this. This is a legal argument that is to be made. So, and I've been instructed to put something on record. And I do so without having had the opportunity to make it, to alert my learned friend of this, because it only came to my attention now while I'm sitting here. And it goes to the point of the complaint by Ms. Messi of the inability to consult in the commission.
Is it not Missy? Is it?
Miss Missy. No, apologies.
Yes.
Maybe I've got soccer on my brain. It's only come into my possession. I'm instructed to put it on the record. And it's a message from the area commissioner for DC, Department of Correctional Services, Commissioner Khoza. And what he says, and this is received at 11:36 this morning, and as I said, I'm instructed to put it on record. I'm not going to read the entire thing into the record, just the factual part, not the comments, if I can put it that way. So the relevant part of the message is facts provided are not true. I am not even aware of the challenges advanced to the Commission. I think the challenges that were complained of. And then the next message, they consulted for 3 days and we are prepared to make concessions anytime because we understand the importance of the Commission. I checked with the head of the center, Mr. Kabengu, on all these challenges. He also denied to have created any disadvantage to them. So that's a message from the area commissioner Khoza. And as I said, Chair, I'm just putting that on record. None of that actually changes the legal position that is before you. And the legal position is that a stated intention to launch an urgent application does not itself suspend this Commission's proceedings. Unless and until there is an order from a High Court that interdicts the Commission from proceeding, it can continue, subject, of course, to the Chair's discretion.
He was my business partner and is a witness in the Medicare matter. I am therefore exercising my constitutional right as an accused not to respond to or answer any questions pertaining to him or our relationship.
Now, he was your partner in the Medicare matter, and you say you are exercising your constitutional rights. I just want to understand, is this an exercise of constitutional rights in respect of any and all affairs of Medicare? Or is it only in respect of the SAPS contract for which you are currently facing charges?
Yes, only the SAPS contract.
Only the SAPS contract. Thank you. You proceed then to deal with the next person, and at paragraph, you identify them and deal with their relationship at paragraph 92, or your relationship with them.
Around Mohoti, I have answered this aspect when I gave evidence.
So in effect, you're saying you've got nothing further to add to what you've already stated?
Yes.
Okay. Then lastly, I think at paragraphs 93 and 94, it's the last person.
Hangwani Mogen Maumela and Suleiman Karim. My legal team is in the process of collating evidence in respect of the said persons, which will enable me to move fully with awareness of an explanation of my rights, answer questions about them. I thus reserve my right to supplement this affidavit. I reserve my right to provide the Commission with any further and supplementary sworn statements necessary in the proceedings, in these proceedings.
Can I just clarify paragraph 93? You say your legal team, quote, is in the process of collating evidence in respect of these persons being Mr. Hlangwani Morgan Maumela and Mr. Suleiman Karim, which will enable you to more fully, with awareness of and an explanation of your rights, answer questions about them, end of quote. Can you say that in simpler English? What do you mean? I understand that they're in the process of collating evidence in respect of these persons, but I'm not sure I understand the remainder of that sentence. Are you able to assist? What do you mean that the evidence that they are collating will enable you to more fully, with awareness of and an explanation of your rights, answer questions about them?
I think this is a typing error.
Okay, so I'm not that bad. Let's try and correct it. What did you wish to express?
Documents that will support that I do not wish to answer these questions because of self-incrimination. This morning I've managed to get a document that I already supplied to my legal counsel.
I'm not sure I understand. It's a very cryptic answer you've just given, so I'm not sure I understand.
What I'm trying to explain to you is,
Yes.
like the first sentence saying that I'm in the process of collating evidence.
Yes.
So maybe I was supposed to say documents that will prove that I'm a suspect and I'm being under investigation together with Mr. Maumela and also with Suleiman Karim.
Okay.
Sorry, Commissioner, if you can remember, last week I already touched on the Suleiman matter, and then you asked that I should bring an unsigned, what is it? An unsigned
Loan agreement?
Loan agreement.
Yes.
So this is what I had that loan agreement, but I couldn't just find it. So what I had is only the document in relation with Mr. Maumela.
Okay, now, so you say that those documents will prove you a suspect. A suspect in what? Or which cases?
suspect in, I think it is money laundering, I think.
And that is in relation to both the persons identified there,
Only with Maumela.
or with Mr. Maumela? And when can we expect these documents to be submitted? Because you say that your legal team is in the process of collating them.
They are already in possession of those documents.
Okay. I take it that they're in possession of the documents with a view to share with the commission.
They will advise on that because they are under investigation. I don't know.
Or you just gave the documents to your
Chairperson, if I may be allowed to address the commission in relation to that.
Yeah.
We couldn't just take it off word that he says that he is a suspect, and we needed to confirm before he would be able to make such an allegation of vermin before the commission. And so he had to look for the document, which unfortunately, as I stated, he was unable to give it to us, the team yesterday. This morning, he did give us the document, and it places us in a position where we can give, or rather he can make that statement on affidavit that he is a suspect and would be claiming his rights to privilege in terms of section 3(4). Sorry.
Now,
Would need to supplement, if I may, would need to supplement his affidavit so that he's able to make those averments and give you the correct facts.
so is it the intention of Mr. Matlala and or his legal representatives to share the actual document that demonstrates he's a suspect?
Ms. Missy?
Determine whether, to what extent he can claim his right to a privilege. So provisionally, I would say yes, provided that we get a timeline in which we are informed that the supplementary affidavit needs to be in at a particular time. And then it allows us to look into the document and determine there isn't everything that's privileged that this allows us to hand it over to the commission.
Is there any problem sharing it with the evidence leaders right away?
Chairperson, I have not looked at it in detail. It's a document that immediately after we had engaged, he came down, he handed it over to me. I quickly glanced over it, so I can't answer that question definitively.
Is it a privileged document? Because if it is not, I would not understand why it cannot be shared immediately.
Chairperson, I suppose if you have to ask if it is a privileged document, I do not believe so, because the investigators would have a copy of it.
Then it should just be shared with the evidence leaders. So as you look whether there is a basis for claiming privilege, the evidence leaders will be looking at the document for themselves as well.
Noted. Share them on those bases. We should be able to share it.
It will be shared this afternoon still.
That's correct.
Thank you.
Thank you, Chair. Thank you, Advocate Missy. I think it should, because as things happen in the commission, documents become available and they are added to the exhibit bundle. So too, regardless of their source, so too shall this one. And this document is important. As a result, I'll have to park the issue I intended to raise in respect of 93. It's important because it would appear, Mr. Matlala, that you have adopted this posture regarding almost all the issues or the persons you've been asked about. If we go then, before I forget, that is the conclusion of the supplementation of his statement. You confirm that that paragraph 94 is the end of your affidavit.
Yes, I confirm.
So then you have given your supplementation. So then,
Mr. Law,
yes.
I don't want to get ahead of you because it may be that you're still coming there. When I looked at 2.2 of the 10.6 notice read with Schedule 1, according to my reading, item 5, the person who appears as number 5, there's still not answer to the question in 2.2. Because 2.2 said, explain your history and or relationship, direct or indirect, with the listed law enforcement officials in Schedule A. And then when you go to Schedule A, it is 28 people.
Yes.
But on my reading of both affidavits, I thought it was an omission in the first one. And the second one was supposed to supplement. But I don't see in the second one where it deals with the name in item 5, unless I've missed it.
No, Commissioner, you haven't. Mr. Matlala, you understand we referred to Schedule 1 and the Regulation 10.6 notice, correct?
Okay.
We discussed the people listed in that document at page 7. And you will recall that in your original statement, when you, from page 12, you then dealt with, at paragraph 14, you dealt with a cluster of persons, 13 of them, from General Masemola to Major General Temba, about whom you said you will not be able to say anything regarding your relationship with them because they are your co-accused in the Medicare matter.
Okay.
From paragraph 15, you then dealt with some of the remaining persons on that list. You see that?
Yeah.
And there you dealt with Minister Mkunu, Patlane, General Patlane, General Mkwanazi, General Fani, and General Khan. You see that?
Yes, I do.
Now, in your supplementary statement, you then deal, or you purported to deal with the remainder of the persons you had not spoken of. And in this regard, as we looked at your statement, you, at paragraph 71, page 14, you once again deal with Minister Mkunu. You deal with former Minister Bekitele. You deal with, once again, with General Patlane at 15. You once again deal with General Mkwanazi. And you deal, followed by General Fani and General Koza. This is the affidavit we've just looked at. General Khan. He did sound. There has to be an explanation, Chair, somewhere on my papers there must be a Koza. I apologize for that, General Khan. So you deal with those at your paragraph 71, starting at page 14 of the affidavit. You see that?
Yes, I do.
Then we went further in your affidavit at page 18, from page 17, from paragraph 89, you deal with Mr. Msibi, the late. You deal with Mr. Van Veek. Once again, Mr. Mkhotsi, and then you deal with Messrs. Hangwani Maumela and Mr. Suleiman and Suleiman Karim.
Yes, I see that.
Now you confirm, if you go back to your annex Schedule A, that item 5 required you to speak about your relationship with Lieutenant General Shadrach Sibiya. And the question posed by Commissioner Kumalo is that even in your supplementary statement, quote unquote, you have failed once again to deal with your relationship with General Sibiya. You note that?
Yes, I do.
I think then perhaps this might be your opportunity to explain to the commissioners why you elected, notwithstanding that you were given a further opportunity to deal with that relationship in the terms as requested of you.
Oh, firstly, if we can remember, Commissioner, you asked me about this goes to General Sibiya, but I need to take you back. You asked me about my interactions with General Mkonazi. What was it that was discussed during the meeting? And I only told you about the Medicare tender and the warrant. So, and I said some of the things I could not talk about them because I wouldn't want to prematurely disclose my defense strategy. Because if you go back, and now I mentioned about General Sibiya, and the very same recordings that I was talking about, his name has been mentioned there. And I said, those recordings are under investigation, and I do not know what actually are they investigating me about in those recordings. So I did not say anything about him because I did not want to somehow end up incriminating myself.
I think, Mr. Matlala, the question is, what is your relationship with this person? So it has nothing to do with offenses that are under investigation and the possibility of self-incrimination. You are being asked to explain your history and or relationship. Take Mr. Van Wyk, for example. You've set out what your history and relationship is with him. Then you say, because he's a witness in the Medicare matter, you won't say anything further. But in relation to General Sibiya, you don't even say you know him. You don't even say you have a history with him.
Okay.
And that is separate from whatever issues are being investigated and may be the subject of criminal proceedings. So I would expect you to please answer the question, what is your history and relationship with General Sibiya? And then at a stage where you need to assert your privilege, you may do so. But I cannot accept that you are not even able to say, I know the person.
I understand, Commissioner. So I will say I know him because of at some point I went to his office to make a complaint about the occupation of the lease agreement that I had with Public Works. So that is the first time that I got to know of him.
The what of the lease?
The lease agreement, I had a lease with Public Works for the hospital that is situated inside SAPS College, which is in Pretoria West. So and then I couldn't occupy that hospital. So that was my first time that I went to him to complain about that.
Perhaps to assist you, please let's go to the deal with each incident as to the purpose of that meeting and how it came about.
The first time I've already mentioned it. And the second time is when I was going to get a feedback of what I was complaining about.
And how did you get that feedback? Where? And
I went to his office also.
once again?
Yes.
And this was to get feedback on?
The Public Works lease agreement.
Okay. And who arranged that particular meeting for you?
I think it's Sergeant Ngosi.
Sergeant Ngosi. Do you know, how did Sergeant Ngosi communicate with you that the meeting, he has succeeded in arranging this meeting?
He had my telephone number.
Say that?
He had my phone number.
You still don't tell me how he communicated with you.
I'm saying he called me.
Okay. Now,
and when he called you, did he call to say General Sibiya wants to meet with you to give you feedback? Because it's Ngosi that calls you.
Yes.
Is that how it happened? Thank you. You said yes, Mr. Matlala.
Yes, yes.
oh, I too had missed the answer, sorry. So that is the second time. Now, the next time?
I think I will confuse the timelines because it's a long time ago, but
Okay.
there was an occasion where he asked me about the Jerry Boshoga. So I do not know whether it was the third or the fourth time. I don't know that.
Now, can you tell us more about that engagement? How it came about and who initiated it?
He initiated it, yes.
Directly with you or through Sergeant Ngosi again?
Like I said before, he never called me even once.
Okay, through who did he do this?
With Sergeant Ngosi.
And what about Jerry Boshoga? Did he want to engage you on?
I think it was after the raid from my house, because the police came to my house and then they said that they were looking for a kidnapped victim.
Okay.
And then later I just don't know, I can't remember when, but at some point I went to him and then that's when he asked me that, what do I know about that?
Oh, you went to him?
Yes.
Is it back at the office now?
Yes.
Who helped you to set up that meeting?
I said it was Sergeant Ngosi.
No, the Sergeant Ngosi, remember we stopped counting and I do accept that it's a long time, so you won't exactly know whether it's the second or third. Sergeant Ngosi organized for you to get the feedback on the lease agreement. That much you said. So now this is yet another meeting and you didn't want to commit as to whether it's the third or the fourth. This is regarding Mr. Boshoga. You said he initiated it. You said the General Sibiya initiated it and you said he did so through Sergeant Ngosi.
Yes, I said.
And you said you went to him?
Yes.
At his offices?
Yes.
And so he requested to meet you?
Yes.
What about? Did he explain?
Are we still on?
On Mr. Boshoga? Yes.
Yes. Yes. It was about that. He asked me what I know about that.
So then, if I understand your communication channel, he would ask Sergeant Ngosi what you know about that. Sergeant Ngosi would ask you in turn what you know, that General Sibiya wants to know what you know about that. Your response would be, no, I don't know much, or I know whatever, and then is that how the communication works?
Oh, no.
Oh, please enlighten me.
He asked him to arrange a meeting, then I went to him.
Okay.
And then that's when he told me.
So he initiated this engagement with you?
Yes.
Do you know in what capacity he did so? Was he investigating this kidnapping, or was it as an interested person, as a relative? Do you have a sense of why he reached out to you on this matter?
Yeah, I think he was, because what he said to me, but I don't know what to make out of that, but he said if he can crack that case, it will help him a lot. So I don't think it was because of he was a relative or something.
Okay. So he initiated this contact for purposes of investigation?
I think so, yes.
Now, if that would be in his official capacity, I take it, as a police officer, I think a senior ranking member of the service.
Yes, he
it would be
was.
official.
I don't know how we'll justify it to be official, but he just called me as a police officer, so I don't know.
And that's precisely what I'm trying to determine. It's a police officer.
Yes.
You have been questioned about the kidnapping of Mr. Boshoga. I take it was not by him the first time when you say they came to your residence.
Yes, yeah.
So now we know that he subsequently becomes involved in it by requesting a meeting with you. Correct?
Yes, that's correct.
Hence my question, did you understand him to be investigating that disappearance of Mr. Boshoga? What was your understanding? What process were you engaging in, seeing as so far you had just met him twice about the lease agreement?
But as a senior police official, maybe he will refer the investigation to someone else. I don't know how it works, but what I know that he called me and then he asked me questions in relation with Mr. Boshoga.
So you don't know whether he was doing that as an investigator into the kidnapping?
I cannot tell that. I don't know.
Okay. And were you able to respond to his questions to satisfy his curiosity?
I think so, yes.
Okay. Now, you we would have said that's your third meeting. But you did say that it was some time ago, so now you're no longer so sure. I will just talk about the next contact you had with them. When was the next, and who initiated it, and where, and what about?
Okay, let me say this, because all of his requests to meet him was through Sergeant Ngosi. So from now on, whenever he called me, it's through Sergeant Ngosi.
Okay.
Yes.
So then, before you get to my question, if he was an investigator in this Mr. Boshoga's disappearance, shouldn't he have contacted you directly? Isn't that what investigators do? Couldn't you have obtained your number from Mr. Ngosi and say, I, as a general in the police service, I need to talk with Mr. Matlala for whatever reason, because I'm investigating a kidnapping? Why couldn't he contact you directly?
That I cannot answer. I don't know that.
So you did make the point that all future and past contact with him was initiated through Mr. Ngosi. As a matter of interest, did you ever inquire why or who made Mr. Ngosi the intermediary between the two of you?
There is, I think it's Mr. Ngosi himself who started this thing.
How does he do that?
Because he's the one who gave me his his email address.
Yes, the first time I can understand, but why couldn't you then have your direct contact with General Sibiya after that, after the initial contact? Why did you always need to work through Sergeant Ngosi?
I do not know that, but that's what was happening. I don't know that.
It never crossed your mind that by now you are on your fourth contact, the one we are going to discuss next, that perhaps your relationship has developed to a point where you can contact each other directly?
Commissioner, when that thing was happening, obviously I wouldn't know by then, but now I will understand why that was happening. But unfortunately, what was happening is something that I cannot speak about. I think I requested that some part of my evidence I will request, because I'm under investigation. I'm really under investigation. I'm not making this up. So I asked that maybe if it's possible that I can, some of my testimony can be in private, because I cannot risk incriminating myself. That I cannot do.
Does Mr. Boshoga's kidnapping have anything to do with Medicare 24, which we know is the case you are currently facing in
Medicare 24?
Yeah. You have always invoked Medicare 24, and I'm interested to find out now whether Medicare 24 is relevant to the issue of the kidnapping of
No, it's not.
Boshoga.
No, it's not.
Okay, so Medicare 24 is out of the way. So what is the basis of...
Get to this point, and I'm addressing you as well, Mr. Matlala, on this. We did not have to get to this point about whether or not this Section 204 statement or affidavit or the contents of it should be divulged. Mr. Matlala could and should actually have responded to the question directly. If Mr. Matlala said, your question relates to ABCD point, which is about one of the crimes of which I have been charged, therefore I risk incriminating myself, that we would understand. There is no need for him to refer to the Section 204 statement as some umbrella cover for his protection. As I said earlier, there is authority from the Constitutional Court that says you must clearly identify the crime to which you are referring in asserting your privilege. And then that should take you to whether, in the face of that, the question put to you is a question that you should or you should not answer based on whether the privilege under those circumstances can be asserted. You don't have to refer to Section 204 or the statement that you made under Section 204 and to then use that some overarching protection. Once it's in the statement, therefore, I cannot answer questions relating to it. It should not. I see your junior next to you is shaking her head. Maybe she's going to give you some brilliant point on why I'm talking nonsense. So we do not have to go there. We are not asking for the contents of the Section 204 statement. All that we want is, because Mr. Matlala is asserting the privilege, Mr. Matlala should say, this is the crime, and this is how your question impeaches on my privilege. That has nothing to do, and it should not have anything to do with reference to the Section 204 statement. It does not have to. And I repeat what I said right at the beginning, which is that without this umbrella cover all that Mr. Matlala uses, we should not have been in this position whatsoever. So much that I will perhaps, I'll let you respond. Depending on your response, after the advice from your junior, I will then ask Ms. Silo to repeat her question. And I hope Mr. Matlala has heard me when I say, we do not have to just broadly and in general terms refer to a Section 204 statement and then say, every and anything that relates to the questions you are asking me is contained in that Section 204. That's not the test. The test is there a crime? What is that crime? How does the question being put to you relate to that crime? And are you therefore entitled to assert the privilege? The test is not, this has somehow been touched on in my Section 204 state. That's not the test. That's simply not the test. Yes.
Chairperson, if I might just get a moment to just confer, because I can hear as well that my...
Suggested that you cannot go in any further detail as to that engagement, and for that purpose you relied on Section 204 statement. So now it says you can't, not in the manner that you choose to, because in any event that statement itself has become null and void. So then I repose my question. Can you briefly state to the commissioners the nature of the engagement you had with Advocate Sibiya, General Sibiya, about the kidnapping of Mr. Boshoga? My apologies, General Sibiya.
I think on that issue, we already said that he asked me what do I know about it, or you want me to explain what did I say to, after he asked me what did I know about this kidnapping, do you want me to explain what did I say to him?
Yes.
Okay. Yes, he started by asking me that why are they accusing me actually of that crime? And I took him back and I explained to him that as soon as Jerry was kidnapped, I suspected two things. The first one was I went to Jerry's house together with Jerry's brother, and then Jerry's brother said to me, I must ask Jerry's wife to give me Jerry's cell phone, because should she find out that there is Jerry's side chick's number in that phone, she will go crazy. And then she said I must lie to her and say this phone is going for investigation. And I did that. That's the first point. So the second one is I told Jerry's wife and Jerry's brother that why don't we tell the police exactly what was Jerry doing, so that at least when they looking for him, they will know which direction to look for. And then I think those two things might have triggered what Jerry's wife did to end up saying, I kept Jerry at my house, which is not true anyway. So, but those are the things that I discussed with General Sibiya.
And are you able to say what was the outcome of that engagement? Because it's not clear whether he was talking to you or with you in his capacity as an investigator, having taken over the investigation, or purely as a senior police officer where others are investigating that kidnapping.
What he said to me is, he said to me that if he can crack that case, it will help him a lot. So I will assume that he was doing that as a police officer, obviously, because if he wanted to be the one maybe to crack that case, then he wanted to know what do I know about it, since Jerry was my friend.
And I think earlier I asked whether after that engagement you had any further interaction with him about this matter.
The kidnapping matter?
Yes.
No, he never, it was only that time.
Okay. Now, you recall that we were dealing with these issues because paragraph 2.2.3 and 2.2.4 had inquired of you the nature, extent, and frequency of communications and physical meetings with General Sibiya. We had said this perhaps is about your third encounter with him. When next did you meet with him and for what purpose?
The other encounter I said is the one that I do not want to talk about it because I'm being charged with corruption. I'm not talking about 204. I'm being charged with corruption, and then they also investigating him on that matter. So,
please say the last bit again, and also
the investigators, they are also investigating him. I'm describing the crime. So yes. I said I'm being charged with corruption.
Is this in the Pretoria case?
The Medicare, yes.
The Medicare case?
Yes.
Oh, this is corruption in the Medicare contract?
Yes.
Is it part of the ongoing criminal case, or would that be an extra charge?
Ongoing criminal case.
So you then, this corruption that you fear you may face a charge for arises from your physical meetings and gatherings and communication with General Sibiya.
That is correct.
And would both of you be charged with corruption, or just you?
I'm already charged, so I'm saying I do not want to say things that would end up making my trial difficult for me. Basically, what I'm saying is it will infringe my fair trial rights.
Okay. So that will infringe your rights in the ongoing corruption charge in what we call the Medicare.
Yes.
Because corruption is one of the offenses you are charged with.
Is this the IDEC investigation?
Yes, that's correct.
And this would relate to your interaction with General Sibiya. You may disclose something, you say, that would compromise your defense against the corruption charge if you were to speak about this fourth interaction with General Sibiya.
That's correct.
Okay. And thereafter, any other?
There's two occasions, but both is the same corruption charge, yes. I'm not mentioning when I went to see him in his office for Jerry Boshoga issue and also for the public works hospital lease.
So, if I understand you correctly, after your engagement regarding the kidnapping of Mr. Boshoga, you met with General Sibiya 3 more times.
Commissioner, I'm just saying, I cannot guarantee that it's 2 or 3. I'm just saying from the top of my head, I'm not sure about that.
Oh, and where's my 3? You had said, I said, when was the next time you met? And then you brought up the corruption case in Medicare. And I say, beyond that interaction, any other, you say 2 other occasions. That's how I land on my 3.
No, I said except the two other occasions when
Oh, okay.
we met in his office. 3 occasions, actually.
So now you had this interaction that could potentially undermine your defense in the ongoing corruption case. I want us to get past that interaction. I want the next time you met with him.
There is no next time.